Welcome to Responsible Employee Training under Title IX for employees of Clay County District Schools. My name is Courtney Bullard, and I'm going to be taking you through this brief course. I'm a 20-year practicing attorney in education law specializing in Title IX compliance. You can learn more about me and my team at our website, www.icslawyer.com. Title IX is a federal law enforced by the Office for Civil Rights under the Department of Education. The law prohibits discrimination based on sex in a school district's education, program, or activity. In May of 2020, the Department of Education enacted new regulations that mandate many aspects of a school district's obligations to respond to allegations of or incidents of sexual harassment that it is on notice of. Title IX also covers gender equity in athletics, as well as pregnancy discrimination. However, for purposes of this course, we will be discussing your obligations as an employee and the school district's obligations to respond to sexual harassment. The Department of Education states that a school district has actual knowledge of sexual harassment or allegations of sexual harassment when an employee of an elementary or secondary school has knowledge of that conduct. Thus, knowledge to a school district employee is imputed to that school district, which means once the school district has knowledge of alleged sexual harassment, they have an obligation to respond in accordance with Title IX. All employees of the school district are designated as officials with authority under the new Title IX regulations. That includes teachers, teaching assistants, administrators, administrative assistants, coaches, bus drivers, cafeteria workers, maintenance staff, substitute teachers, and others. If you're taking this course, you have been designated as an employee or official with authority for your school district. Why are school district employees considered responsible employees or mandatory reporters under the new regulations? The Department of Education states that in school districts, the school administrators, teachers, and other employees exercise a considerable degree of control and supervision over their students. Thus, the requirement that employees report known sexual harassment, including reports or allegations of sexual harassment, furthers the Title IX non-discrimination mandate in a manner that best serves the needs and expectations of students. The school stands in the place of a parent with respect to certain authority over and responsibilities for its students. Before we get into what might constitute sexual harassment, it's important that you know that Title IX applies to student-on-student sexual harassment, employee-on-employee sexual harassment, employee-on-student sexual harassment, otherwise referred to as educator sexual misconduct, and student-on-employee sexual harassment. Adult misconduct or sexual abuse is a particular concern to parents, students, educators, and the Department of Education in the school setting because of the student-teacher relationship. It's also referred to as educator sexual misconduct. Offenders or abusers can be male or female. And because most abusers seek to conceal their sexual contact with students, they often target students they can control. While in some cases control is by force, most occurs in a more subtle manner characterized as grooming. In the process of grooming, an abuser selects a student, gives the student attention and rewards, provides the student with support and understanding, all the while slowly increasing the amount of touch or other sexual behavior. Although not every instance of educator sexual misconduct includes a grooming phase, it is important to have an understanding of the behavior. And not all abusers are the educators in a school. They could be administrators or other employees. It is also important to understand that only around 6% of children report sex abuse by an adult, keeping it secret or only telling a friend. Bottom line, sexual harassment and the notice requirements regarding your obligations as an employee is not limited to student-on-student matters, and I encourage you to seek out more information and resources on educators' sexual misconduct to ensure you understand instances where you may be on notice of a situation involving an adult or educator as an abuser. So what type of conduct constitutes sexual harassment? Sexual harassment is specifically defined under Title IX. It is defined as conduct on the basis of sex that satisfies one or more of the following three prongs. The first prong we refer to as the quid pro quo prong, where an employee of the school district conditions the provision of an aid, benefit, or service of the school district on an individual's participation in unwelcome sexual conduct. The second prong is unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the recipient's education, program, or activity. Recipient here just means your school district. And the third prong are four definitions that are brought over from the Clery Act, which is a federal law that mostly applies to institutions of higher education. Those definitions are sexual assault, dating violence, domestic violence, and stalking. I mentioned those four definitions that are contained in the Clery Act. Sexual assault is defined as an offense that meets the definition of rape, fondling, incest, or statutory rape as used in the FBI's crime reporting system. A sex offense is any sexual act directed against another person without the consent of the victim, including instances where the victim is incapable of giving consent. Here you see the definitions of rape, fondling, incest, and statutory rape. Note that the definition of incapacitation and consent may be specifically defined in your policies and procedures, but the overall general definition of sexual harassment and sexual assault will look very similar to this, although your school district may specify under rape, forcible, and non-forcible offenses as well. What's important is that you look to your school district's policies and procedures and make sure you understand these definitions. Dating violence is defined as violence committed by a person who is or has been in a social relationship of a romantic or intimate nature with the victim. The existence of such a relationship shall be based on the reporting party's statement with consideration of the following factors: the length of the relationship, the type of relationship, the frequency of interaction between the persons involved in the relationship. Here, while again it's important that you have familiarity with this definition, it's more important that you note that dating violence is a type of sexual harassment, and if you are on notice of or something is reported to you that may constitute dating violence, it is imperative that you report that information to your Title IX coordinator. Domestic violence is also included in the Title IX definition of sexual harassment. The definition is listed here and will also be in your policies and procedures. What's important again that you understand is that domestic violence is included under that definition of sexual harassment. Therefore, you will have reporting obligations if you're on notice of this conduct. Finally, you have the definition of stalking provided under the definition of sexual harassment. Stalking is engaging in a course of conduct directed at a specific person that would cause a reasonable person to fear for the person's safety or the safety of others, or suffer substantial emotional distress. Within this definition, you have a definition of course of conduct, substantial emotional distress, and reasonable person. Course of conduct means two or more acts, including but not limited to acts in which the stalker directly, indirectly, or through third parties, by any action, method, device, or means, follows, monitors, observes, surveils, threatens, or communicates to or about a person, or interferes with a person's property. Again, this is a complex definition that will also be provided under your policy. It's important that you understand Stalking is a form of sexual harassment. In addition to these definitions, sexual harassment may also include actions motivated by gender or sex, such as bullying or hazing. Often these actions overlap with sexual harassment, so be sure to keep an eye out for those and understand that there may be an overlap. Vandalism or arson, or program equity decisions, including admissions, athletics or club participation, hiring, firing, or promotion. Your school district is responsible for responding to sexual harassment that occurs within its programs or activities, whether on or off school grounds. Examples may include, but are not limited to, various school-sponsored events and activities, such as field trips, athletics events, dances, or club activities. As an employee with an obligation to report, you need to know when or how you might be on notice of sexual harassment. You may be on notice of sexual harassment because you directly observe the conduct personally. However, notice is not limited to situations where you have direct knowledge of conduct through observation. An employee or student who is experiencing the harassment may report it to you directly. There may also be instances where you receive a secondary report of the harassment from a friend, classmate, or coworker of the potential victim. In all of these examples, you are on notice, and once you are on notice, the school district is deemed on notice and must respond under Title IX. The Title IX coordinator for your school district coordinates all of the district's compliance efforts under Title IX, including its obligations to appropriately respond to alleged sexual harassment. Once you're on notice of sexual harassment, you must immediately report it to your Title IX coordinator, regardless of how you became on notice. Once on notice of potential sexual harassment, your role is to provide the information immediately to the Title IX coordinator. It is not to conduct an investigation or inquiry. This means that you are not to ask questions of those involved about the conduct to determine if it is actually conduct that constitutes sexual harassment and or if the allegation is true or not. That is the role of the Title IX coordinator. Once on notice, immediately pass the information on to the Title IX coordinator who will make those determinations. If you have any doubt as to whether conduct constitutes sexual harassment, report it to the Title IX coordinator. Do not hold on to the information. The Title IX coordinator for your school district is Treasurer Pickett. You can utilize any mechanism for reporting: email, a phone call, or in person. After you report potential sexual harassment to your school district's Title IX coordinator or other administrators designated, the Title IX coordinator may offer supportive measures to the student or employee who experienced the harassment. An investigation into the conduct may occur, with a possible determination as to whether there was a violation of the school district's policies and a necessary sanction. The process is dictated by your school district's policies and procedures, but the matter will be handled in a confidential manner to the extent possible, with consideration for the parties' privacy. In addition to your responsibility to report conduct that may constitute sexual harassment, a reminder that you also have obligations to report any known or suspected child abuse or neglect to Child Protective Services under your state law. Often these obligations overlap, so be sure you understand when that may occur, and that if they do overlap, you report both to CPS and your Title IX coordinator. As we conclude this training, there's one other important item I need to point out to you, and that is a prohibition on retaliation. The regulations state that no school district or other person may intimidate, threaten, coerce, or discriminate against any individual for the purpose of interfering with any right or privilege secured by Title IX, or because the individual has made a report or complaint, testified, assisted, or participated or refused to participate in any manner in an investigation, proceeding, or hearing. intimidation, threats, coercion, or discrimination, including charges against an individual for code of conduct violations that do not involve sex discrimination or sexual harassment, but arise out of the same facts or circumstances as a report or complaint of sex discrimination, constitutes retaliation. If you have any questions regarding your reporting obligations, this training in general, or your policies and procedures, please contact your Title IX coordinator, Treasurer Pickett. I encourage you to pull the Title IX policy for your school district and familiarize yourself with it. Remember that it is imperative that you report any alleged or suspected sexual harassment immediately, not only so that your school district can comply with Title IX, but also to ensure that Clay County District Schools provides a safe and healthy learning and working environment for students, teachers, and staff.